Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today's a pretty good day. Late last night, we scored a major victory against the ATF and their so-called engaged in the business of final rule. Not only did we score a win, but the judge just absolutely eviscerated them. So we're going to talk about what just happened and what the judge said. Definitely stay tuned to this one. Hey, real quick before we get started, your engagement is always appreciated. It's what helps this channel grow, and it's what helps these topics get out there to more and more people. If they are isolated, then nobody's going to see what's going on here, and we need more people to know what's up. So if you are not subscribed yet, consider hitting that subscribe button. It's free. It only takes a second, but it helps us out quite a bit. That little alarm bell will let you know when new videos come out, and an interaction like a thumbs up or a comment is always very helpful as well. So with that being said, let's get to the video. Okay, so let's go and talk about what's going on here with this big win, because I'm sure you guys know how important this actually is. You know, the engaged in the business of final rule basically made it so that even simply offering up something for sale could get you in some hot water. That would technically be a violation of the final rule. You don't actually have to do anything. You just have to simply consider doing something, and bam, there you go. You're caught up in it. So this is a huge problem. Well, a federal district court judge out of the Northern District of Texas, specifically the Amarillo Division, placed an injunction against that final rule, which is absolutely fantastic. Is the case of Texas et al. V. ATFE, again challenging the APA, so the Administrative Procedures Act, and the constitutionality of that final rule. Now, you guys are going to like this one, because in the judge's order, he absolutely destroys the final rule. He points out the contradictions and the hypocrisies. And so it's important for us at least to read just a little bit of this to get an understanding of exactly what happened here. And not only that, but who is covered under this injunction. So again, no longer enforceable for these people. Now, I would like to see this for the whole country, but I believe that that is coming. So right now it covers these plaintiffs, and it really does point out that there are some massive benefits to being a member of some of these organizations like the GOA, the GOF, FBC, and stuff like that. The benefits have been rolling in for quite a while now, so hopefully you guys have seen that. Before the court is plaintiff's motion for a preliminary injunction filed May 9th, 2024. Defendants filed their response on May 14th, 2024. Having reviewed the briefing and relevant law, the court grants the motion. Defendants are hereby enjoined from enforcing the regulations. Quote, definition of engaged in the business as a dealer in firearms, unquote, against the plaintiffs, which are going to be Texas, Louisiana, Mississippi, Utah, Jeffrey Tormey, GOA, the GOF, the Tennessee Firearms Association, the TFA, and the VCDL, the Virginia Citizens Defense League, pending the resolution of this lawsuit. Now, like I said before, I would like to see this for the entire country, but because the judge said that the plaintiffs have a likelihood of success on the merits here, I feel that we have a very good chance of seeing a win for the entire country. Now, this just covers those named plaintiffs. If you are a member of one of those organizations, you can actually enjoy the benefits of that right now. As a matter of fact, the ATF actually tried to get the names of the members so that each individual person could be named and the injunction would only apply to them, but the judge denied that. So as a matter of fact, anybody who is a member of any one of these organizations or lives in one of those states that was mentioned, right now, that injunction applies to you. Now, further on down below, the judge actually says that the final rule contradicts the text of the BSCA, and he writes, here, the final rule clashes with the text of the BSCA in at least 3 ways. First, it inserts that there is no minimum number of firearms to actually be sold to be engaged in the business, quote unquote, for the purposes of the licensing requirement. A single transaction or even the mere offer to engage in a transaction may suffice. So he continues below to say, but the BSCA says otherwise. The term, quote, engaged in the business, unquote, means as applied to a dealer in firearms as defined in section 92(1)(a) 11A, a person who devotes time, attention, and labor in dealing in firearms as a regular course of trade or business to predominantly earn a profit through the repetitive purchase and resale of arms but such a term shall not include a person who makes occasional sales, exchanges, or purchases for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. Now he goes on to say defendants, which is the agency's preferred interpretation, is severely undercut by Section 921A21C's use of 1, firearms in plural, right? Plural. So they say that, just simply the mere offer of one could be enough, but this says plural. The phrase regular course, clearly contemplating a series of events. 3, repetitive, meaning more than once. 4, the section's example of sales, exchanges, or purchases in the plural. So 2, does Section 921A21C require the purchase and resale of firearms, a conjunctive requirement that flatly contradicts defendant's assertion that there is no minimum threshold number of firearms purchased or sold that triggers the licensing requirement. I mean, that right there absolutely closes the door on their argument. So, I mean, that pretty much says it all right there. Now, the judge writes in conclusion, and it's the same thing that we read in the introduction, plaintiff's motion for a preliminary injunction is granted. Defendants are hereby enjoined from enforcing the regulations, definition of engaged in the business, and it says against all plaintiffs pending the resolution of this lawsuit. It is so ordered. June 11th, 2024. So again, that was kind of late last night. Now, there are so many other good little gems in that order that I think you guys would absolutely love, but if we read the entire order, we'd be here for over an hour, and I don't want to do that to you guys. I know you can't get that time back, and time is very valuable. So we're just going to cut this short, but basically this is that judge saying that, hey, not only is this unconstitutional, but it violates the APA, the Administrative Procedures Act, because the final rule is so different from A, what was proposed, but B, from the actual interpretation of the BSCA itself. And so being the fact that it's so different, there is no way that this can be upheld under the APA. So this violates the APA. It's unconstitutional. I believe that we're going to have a win nationwide in this case at the end, but at least for now, it does show you that there is a need to be a part of these groups, because not only are they fighting for you, but they're also fighting for their members, and they got a pretty big win here. So again, if you're in any one of those states or you're a member of any one of those groups, and I don't know if that applies to anybody who signs up to be one of, a member of one of those groups as of today or tomorrow, whether or not that would hold up, I would assume that it does, but I don't know for a fact. Regardless, this is great. This is an injunction against another final rule, and I am excited about it. So I want to thank you all very much for watching. Again, don't forget to hit that subscribe button. Don't forget to hit that little alarm bell that'll let you know when new videos come out. And thank you all so very much for your support. You guys have a good one.